Hello and welcome to the BRR Legal Brief, bringing you the latest legal issues affecting corporate Australia. I'm Kate Ritchie and today we're looking at the battle for market in the tablet and also the smartphone area, which took an interesting turn last week with a US jury ruling that Samsung had breached Apple's patents and ordering that it pay some $1 billion in damages. Joining me to discuss the case and also the broader implications for this market is Scott Sloan, who's a partner in the Intellectual Property and Technology Group at DibbsBarker. Scott, welcome.
Thanks, Kate.
Well, before we look at the broader implications of the decision, can you run us through the US case?
Sure. Well, the stage that we've reached, as you said, is the headline, $1 billion, just over $1 billion awarded by a jury. Mm-hmm. Now, in America, these kinds of cases are heard before juries, which isn't the case in Australia. What they've done is they've found that a number of Apple's patents have been infringed. And it's probably important to state at this stage that we're not just talking about patents in the sense that we normally talk about them here in Australia. We're talking about both design patents, mm-hmm. which we might think of more readily in the area of registered designs, things that deal with the appearance, the aesthetics of a product, as well as what we would consider in terms of patents in terms of their functionality. So a decision has been made, a large number of decisions have been made by that jury, which have resulted in a total of just over $1 billion being awarded, findings of infringement. And now that decision, or those decisions, need to be ratified by the judge who's presiding, and then ultimately that's subject to a further appeal. So we're not at the end of that case yet.
No. Well, they're also not just battling in the US, but more globally in different jurisdictions. Does this win in the US give Apple a leg up in terms of pursuing lawsuits in other jurisdictions?
I think that you'd say that it gives them a moral leg up. It gives them certainly encouragement. It's a significant win. It also probably gives them encouragement in the marketplace, in the market of public opinion, and that's not an insignificant thing in this particular series of battles. This is being fought out not only in the courts but also obviously on the ground in the markets. But in terms of encouraging Apple or Samsung to take actions, I suspect they don't need much encouragement. As you said, Kate, there are a lot of proceedings in a lot of different countries already around the world, and a very strategic position is being taken by both parties to it. So I'm not sure that they would see that this is determinative of, yes, we should now go ahead and launch more proceedings. I think that will be taking place at a much higher level and looking at each jurisdiction, what intellectual property is available for them within those. They'll certainly be analysing the findings. Okay.
And if we focus the decision onto Australian shores, last year Apple was actually unsuccessful in obtaining an interlocutory injunction preventing Samsung from selling one of its tablets to the Australian market. The final decision hasn't been heard in this matter, but given the win in the US, does this mean that Apple's chances of succeeding are higher?
I think that's a long bow to draw. The law in Australia is not necessarily the same as the law in the US, and in many aspects it isn't. The way that we approach registered designs, I suspect, will be slightly different. Certainly there's no jury involved. The decisions are going to be made by the judge in question. And so the Australian court will apply the Australian law. They'll look at the claims of the various pieces of intellectual property and construe them in accordance with Australian practice. And so, no, I don't think you can say that that because they've won in the US, that means that they now are necessarily going to win here. That's far too long a bow to draw. Clearly, both sides will be looking very carefully at why each of them won or lost their particular points, and they'll be bringing that learning back here. No doubt about that. Okay, well, we'll just have to wait and see what does happen with that one. I'd like to, I guess, look at the market. If we look at tablets and smartphones, the look and feel and the functionality is quite similar across a number of the different devices. Given the win in the US, will companies now need to make different decisions when it comes to design and also technology in this area? Well, it is interesting that both both parties have chosen particular ways to present their products. There may be particular reasons why the functionality has to work the way that it does, and indeed some of the Samsung patents go to issues of whether or not there are things that have to be in there in terms of the standards. But the way that something looks and it's presented is clearly much more about decisions on the aesthetics as to what the consumers are looking for, what their research might be telling them is what's going to be successful. This case certainly includes learning around perhaps the need to take innovations a step further, perhaps than they have otherwise in terms of how a product looks, to move in different directions rather than to following quite so closely. So yes, there is obviously opportunity for people to design around the way a product looks, so long as it's still functional, so long as it's aesthetically still pleasing to people. And there's lots of opportunity for people to stamp their own mark on what a product looks like and to make that their own space.
And now I'd just like to look at some lessons. Obviously, Apple and Samsung are massive global corporations. For the smaller companies, is there any lessons that they can draw from this decision?
Well, the first thing is to say the enormity of the verdict in the US. I mean, that is very large, and it has to be considered that my understanding is that there have been some findings by the jury in terms of willful infringement, which raise the spectre perhaps of multiple damages as well. Whether that doesn't carry, of course, back here into Australia, but one lesson clearly is if you're going to launch products, you need to have considered that risk at the appropriate moment in time. Now, I'm sure that the parties here have and did consider those risks all the way along, but for parties with pockets that are not so deep and the appetite for litigation might not be so strong, it's very important that if you're developing products that you're considering what intellectual property might you tread on unintentionally, or what might you need to steer carefully around in order to deliver the product that you have. And you need to do that early enough in the piece so that when your product is about ready to launch, that you don't find some particular disaster waiting for you. And we've already seen in this case that Samsung has already designed around a number of times in order bringing new products to market, particularly in terms of the shape and aesthetic appearance.
Well, it certainly is an interesting decision, and the battle's certainly not over, and I think many people will be watching this very closely. But Scott, thank you so much for coming in and telling us about the case and sharing your insights.
My pleasure.
And viewers, thank you also for joining us. We hope that you can join us next week for our legal brief.